If we made it.
Good morning. Are you Mark Garcia? And will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Garcia, in cause number 25, DCCR 0120, the state has elected to proceed on count 1 only. It alleges you committed the state jail felony offense of theft of material, aluminum, copper, bronze, or brass, from April 7th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with?
Quick procedural move right out of the gate. Waiving the formal reading of the indictment. That's standard in plea cases, but it signals something important. This isn't going to trial. This is a negotiated path. When defendants waive readings and move efficiently like this, it usually means the deal has already been carefully worked out behind the scenes. The real question now, how much mercy is actually on the table? 4 prior felonies, and one of them is for the exact same type of theft. That's not a coincidence.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? Answer out loud, please.
Oh, yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
This is going to be maybe iffy, but we'll look at it when I get. It looks like there's 4 prior felonies. 1 for the same offense, just in 2022. A theft on that same day. A possession of a controlled substance in 2023. And a fraudulent use of possession of possession of identifying information 2023. So it looks like the agreement that you've reached with the district attorney is for a cap of 16 months. Is that your understanding? I want to make sure you understand that, which means you're leaving your punishment up to me. If I follow the agreement, then I cannot give you more than 16 months. I could give you less. It'll depend on the information that's brought to me at a sentencing hearing. You have every right to have a jury come in and determine 2 things. The first is to determine if you're guilty or not. And then if they find you guilty, you can leave your punishment up to them. If we go forward this way, you're waiving that right. And is that what you want to do? Also, just so that you know, if I don't accept that plea agreement, you will be allowed to withdraw your plea and we'll...
That's a pattern. And here's the legal nuance. A cap of 16 months means a judge cannot go above that number if she accepts the deal, but she can go lower. So this is a gamble. He's putting sentencing in the judge's hands instead of a jury's. Would you roll those dice with that criminal history? This is an important safeguard moment. If the judge rejects the deal, he gets to take back the guilty plea. That protects defendants from pleading blind. But notice the tone. This might be iffy.
Go forward at that point. Do you also understand, if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Garcia is not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. If there's anything that you think it's important for me to know, get that information to Mr. Lewis and he'll present it to me on your behalf when we come back. Just anything that you think is good that would help you or help me to help you. All right? Do you have your discovery?
Oh,
Sorry.
Yes.
I just want to apologize again for
Well, let's.
tardiness of last time. You know,
he was a bond forfeiture judge.
Oh, okay. All right. Get Ms. Malfino to sign that real quick. Thank you. All right. Thank you, sir. You can go back with the bailiff. Did you need me to sign that or you got it? Good morning. You're Isaiah Green. And Mr. Lewis, will your client waive the formal reading of the indictment?
He does, Judge.
That's judge speak for, I'm not fully sold. When a judge flags prior felonies like that, they're weighing public safety against second chances. And right now, the scale looks heavy. And here's the pause button. Instead of sentencing immediately, the judge orders a pre-sentence investigation, a PSI. That report digs into background, employment, family, substance abuse, attitude, everything.
Mr. Green, in cause number 24 DCCR 1159, you're charged with a second-degree felony offense of assault on a peace officer from May 14th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. What about a fine?
$500, Your Honor.
There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Green is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that we can get a pre-sentence report done. It'll give us more information about you and your case, and then we'll come back later for sentencing.
The judge wants more data before deciding how much time, if any, he'll serve. This is often a sign the court hasn't closed the door completely. There's still room to influence the outcome. And just like that, new defendant, new stakes. We're moving from metal theft to assault on a peace officer. That's a second-degree felony. Completely different level of seriousness. Watch how the tone and structure shift here. Assault on a peace officer carries serious prison exposure. So if there's a probation deal coming, that's significant.
What is the state's position with regard to a bond?
Judge, his criminal history is mostly clean. He has one juvenile offense and then a dismissed aggravated assault as an adult.
Okay. So what I'm going to do, Mr. Green, based on the nature of your, so there's some misdemeanors as part of this as well.
Yes, sir.
Okay. As a part of the, because of the nature of your plea agreement, what I'm going to do is reduce your bond in your case to $1,000. If you make that bond, it's very important that you take care of a few things. Number 1, you go straight to the probation department and get that pre-sentence report interview done and follow through with everything that has to do with that. If you don't do that, then when you come back, you run the risk of me not accepting the plea agreement. Things could be worse. Do you understand? Also, if you're arrested for anything, if you make that bond, between the time you make it and the time we come back, obviously you run the risk of me not accepting the plea agreement. You understand that as well. And so there was a public intoxication. I'm just trying to see what the issue was. It looks like alcohol.
Yes, sir.
While you're on bond, you're also not allowed to drink alcohol or use any illegal drug. But even though alcohol is legal, you're not allowed to drink any. Do you understand? Okay. Anything else?
I think that'll cover it, Your Honor.
All right, we'll see you back at sentencing.
Thanks, Judge.